The Lucy Letby case has become one of the most controversial and emotionally charged trials in recent history, raising questions about healthcare safety, the justice system, and the role of expert testimony. I'm going to start by sharing a powerful quote from Lady Justice Thirwall, who in her opening remarks said that there was a huge outpouring of comment from a variety of quarters on the validity of the convictions. Her remarks highlight the widespread concern, both in the UK and abroad, about the reliability of these convictions, with critics questioning whether the investigation and indeed the trial were as thorough as they should have been. Lady Justice Thirwall goes on to say that as far as I'm aware, it has entirely come from people who were not at the trial. There is a grain of truth here because although lawyers often rely on written judgments, attending a trial provides vital insights that can't always be captured in legal documents, insights that are crucial to complex cases like the Letby case, where public interest and transparency are paramount. For instance, attending court allows you to observe how witnesses behave and how a jury reacts to evidence and arguments from both the prosecution and the defence. You can also gain insights into the strategies used by both sides and whether they were effective. These subtle details are often not fully captured in written case law. First-hand experience does provide crucial insights, often missed in legal documents, that can shape the outcome of a complex case such as this. However, the opposite is also true. The allegations against Letby have shaken public confidence not only in individual healthcare providers but in the system as a whole. These convictions raise serious doubts about whether infants are truly safe in our hospitals and whether systemic failures allowed these tragic deaths to occur. As a public interest case, authorities need to be careful, balancing the needs of grieving parents on the one hand and resolving the broader public outcry on the other. To fully understand the complexities of the Letby case, it's essential not only to address public concerns, but also to consider the significant legal implications. The case has brought forth crucial questions about the role of expert testimony in trials, the thoroughness of investigations, and the potential here for wrongful conviction, all of which demand transparency and public scrutiny to maintain confidence in the justice system. This means that the public must be given full access to first-hand information. This is the only way that confidence in the system can be restored and maintained. Lady Justice Thirwall's comment might be emphasising the need for direct observation to fully grasp the intricacies of a trial. However, in the context of a public interest case, it's equally important that the public has access to comprehensive and accurate information so they can form their own opinions. In the last sentence, she continues and says all this noise has caused enormous additional distress to the parents who have already suffered far too much. There's no doubt that the parents have endured unimaginable pain and grief. However, if Letby is found later to be innocent of some or all of the charges, it's going to be vital to consider how this might factor into the already complicated emotions of the parents. There are plenty of convictions out there where people have been fully exonerated for their crimes years later after they have exhausted all avenues of appeal. Justice must be sought carefully and fairly here, not just for the public interest or for the critics of this case, but particularly for the families involved. This is why it was absolutely vital for the system to handle the case with precision and thoroughness. It wasn't just about collecting the right evidence. It required more than relying on a single investigator turned expert witness. The complexities of this case demanded input from multiple highly qualified experts from around the world to ensure a comprehensive and unbiased evaluation. One such expert is Professor Jeff Chase from the University of Canterbury here in New Zealand, who challenged the prosecution's claim. He disputed the prosecution's argument that baby Al was harmed by Letby by the alleged administration of 1% of a vial of insulin. Professor Chase, however, found that this claim was at odds with his own research. in this area. He and his colleague Helen Shannon calculated that the range needed to cause harm was between 20 and 80% of a vial, not 1% as the prosecution claimed or Dr. Evans claimed, and there is no evidence to say that the insulin had gone missing on the ward. The role of expert testimony in this case cannot be understated. Professor Chase's research on insulin doses directly contradicts the prosecution's claim, showing that only a much higher percentage of insulin would have been harmful. These kind of discrepancies could ultimately determine whether justice is served. The final element of Lady Justice Thirwall's quote that I want to return to is where she says all of this noise. I think labelling external commentary as noise dismisses genuine concerns from experts and the public at large. While it's understandable that the families are distressed, constructive criticism grounded in evidence is vital to ensure that truth is fully uncovered. Healthy discourse isn't just important, it's a crucial part of our democracy and in the pursuit of justice. While there are valid concerns here, dismissing external commentary as noise overlooks the legitimate concerns raised. And beyond the public discourse, the trial also hinged on the reliability of expert testimony, much of which came from Dr. Evans. He said in one article that those challenging the verdict were grossly irresponsible and their conduct was quite frankly disgraceful. Well, Dr. Evans has expressed frustration with those questioning the verdict and indeed the evidence that he gave. It is essential to remember that challenging a conviction is not reckless. In fact, it is a fundamental part of ensuring justice. We need open conversations where concerns about evidence and expert testimony are heard and addressed constructively. Far from being irresponsible, questioning verdicts, especially in complex cases like this, is a hallmark of a functioning democracy. It ensures that convictions are based on sound evidence and a fair process, and that operates to foster public trust in the justice system. In the Letby case, serious concerns about the evidence and expert testimony have emerged, which deserve careful and measured responses. These are not baseless objections or conspiracy theories. These are legitimate questions about how the legal process handled highly specialised medical data. Using terms like disgraceful risks polarising the discussion rather than promoting open and constructive dialogue. It's essential that, especially in emotionally charged cases like this, the focus must remain on addressing the concerns through facts and reason and not shutting down dissent. While it's crucial to recognise the profound grief that the parents involved are experiencing, it's equally important to ensure that the valid concerns about the trial process are addressed. Ignoring these issues could further erode public confidence in the legal system. The Letby case relied heavily on circumstantial evidence. There was no direct evidence of her involvement in any of the deaths. Circumstantial evidence suggests that something's happened, but it just doesn't directly prove guilt. While multiple pieces of circumstantial evidence can form a persuasive argument, they should be scrutinised carefully. In this case, Letby was never directly observed harming the infants. There was no forensic evidence presented, and this raises questions about the safety of the conviction. Public debate around controversial trials like this one is a cornerstone of free speech and democratic engagement. While it's natural for those close to the case to be upset by some of the discourse, suppressing discussion, especially when valid concerns are raised by medical evidence, undermines the healthy functioning of a society. I want to end this video with a quote from Clarence Darrow, an American lawyer who was a fierce opponent of the death penalty in the US. He said, "You can only protect your liberties in this world by protecting the other man's freedom. You can only be free if I'm free." If this video helped you to think critically about this case, hit the like button and subscribe for more in-depth analysis. Share your thoughts in the comments section below. Your voice matters in these important conversations. For now, take care.